Can you sue a social media app or dating app if you're injured while taking a photo or video to post on that platform? I'm Bill Colarulo. This is Legal Mythbusters. Let's take a look. The answer to this Legal Mythbusters would have been different if asked even a few weeks ago, because in early May 2021, the U.S. 9th District Court of Appeals turned the legal world upside down when they made a decision allowing Snapchat to be sued for the death of 3 17-year-old boys. In May of 2017 in Wisconsin, 3 17-year-olds got into a vehicle and were now going to use the very controversial Snapchat speed filter. They were going to drive as fast as they can when one of them took out their phone to use the speed filter so he could post how fast they were going on Snapchat. Sadly, they got up to 123 miles an hour when they lost control of the vehicle, hit a tree, and all 3 of them died. The parents of one of those children sued Snap, the parent company for Snapchat. Normally, what the courts were doing previous to this case was granting immunity to the tech company, citing Section 230 of the Communications Decency Act, where social media platforms were granted immunity for things that were being posted onto their platforms. But in this particular case, the 3-judge panel decided that this case was not about what was posted on social media, what was posted on Snapchat, but the actual design of the Snapchat app itself, which created an inherent danger for people who were going to use that speed filter. And it was foreseeable that someone who was trying to drive fast and using that filter could get injured. Now, this does not mean that in fact Snapchat and other app companies are going to be held liable. What this was an appeals court who was deciding whether or not that case should be allowed to go forward, because the prior court, the district court, had dismissed this case, citing Section 230 like hundreds of other cases throughout the history of the law. But in this instance, they've now sent it back to the district court for this case to be heard again. What we are probably looking at, and what is almost definitely coming, is going to be that this case will get appealed either by Snap or by the parents of the deceased, depending on how the district court's decision goes. And that will be appealed to the Supreme Court to make a final decision. Depending on that decision, this could have wide ramifications throughout the legal world. It's a very interesting legal argument, and really what it's doing is it's taking these apps outside of the Section 230 of the Communications Decency Act and really applying them more of a products liability standard. To give you an example, if you bought a dangerous product and the manufacturer of that product knew it was dangerous, didn't give proper warnings, could have designed that product differently to make it safer, and you were injured, you may have a claim against that manufacturer under a products liability case. That's kind of what the judge is saying here. The 3-judge panel is saying this is not about what was posted. This is about the design of the app, and that the technology company should be treated like any other manufacturer that allows a known dangerous product to hit the market and people get hurt. We'll see how this unfolds. I'm very curious to see if it gets appealed to the Supreme Court, but very interesting. What do you think? Should app companies be held liable if users are injured by using that app in ways that should be known to the app company are dangerous? Be sure to like and follow for more.